My ladies, my lords, this appeal concerns conditions imposed on HMO licences by the first tier and upper tribunals. The conditions specify the class of person who can occupy the houses, but it's plain from the decisions below that those conditions were imposed on the footing that persons in the relevant class, that is, students, were likely to occupy the houses in a particular way. In other words, class of occupier was adopted here as a proxy for mode of occupation. Now, in analysing the issues, I would respectfully endorse a point made by Lord Carnwath this morning, that it's very important to identify with precision what is the issue of construction and what is the issue of rationality. Issue 1 can, in my submission, be recast in this way. Assuming that persons in a particular class are likely to occupy the houses in a particular way, does the 2004 Act in principle permit the imposition of a condition regulating the class of occupier? That is, in my submission, a question of statutory construction. Issue 2 is this: were the tribunals below entitled to limit occupation to students on the basis that students are likely to occupy the houses communally? And that is, as Lord Carnwath's question suggested, a question of rationality. It turns on the rationality of the condition. Now, on issue 1, I'd like to make submissions subject to your ladyship and lordships under 6 heads. First, the Court of Appeal's construction does not, as a matter of logic or principle, entail the creation for a particular class of occupant of exemptions from the operation of the legislation. Nor does it entail that members of that class must put up with a lower standard of accommodation. Second, it was common practice prior to the 2004 Act, and remains so, to take mode of occupation into account in deciding whether an HMO is suitable for a particular number of persons. Third, the language of section 64 indicates that conditions may be imposed inter alia for the purpose of rendering an HMO suitable for a particular number of persons where it would not otherwise be so suitable. So if, as the Secretary of State concedes, conditions can be used to regulate the class of occupier, such conditions must, in principle, be capable of making an HMO suitable for a greater number of occupiers than would otherwise be appropriate. Fourth, the pre-legislative materials indicate no perceived difficulty with the then existing practice of treating mode of occupation as relevant to suitability. Read against that background, and in any event, section 67 on its face permits the imposition of conditions regulating the class of occupier. Fifth, the Act contains other mechanisms for imposing minimum standards applicable to all HMOs. There is therefore no need to suppose that section 67 must be interpreted so as to prevent a local authority from taking mode of occupation into account in cases where these prescribed minimum standards are met. And sixth, a construction that prevents a local authority from taking into account mode of occupation may operate to the detriment of a class that occupies in that way, by driving up the cost for that class of accommodation beyond the level required to achieve suitability for that class. And that is likely to be an important consideration in particular for students, because they are likely to be particularly sensitive to cost. As to issue 2, the question whether in this case the class of occupiers, students, is a good enough proxy for the mode of occupation, cohesive living, is a question of fact on which the court should be cautious before interfering with the judgment of the specialist tribunals below. If there is a concern that some students do not live communally, the concern can be met by alternative or additional conditions designed to achieve the same effect. So can I turn then to my first head of submissions under issue 1, which I can summarise as no exemptions and no lower standard. Now, the appellant's case, and it's set out at paragraph 27 on MS 87, is that the conditions here seek, contrary to the policy of the legislation, an exception to its operation for a category of persons or a defined set of circumstances. In my submission, that is not correct. We know from the legislative history that one of the purposes of the 2004 Act was to reverse the effect of the Court of Appeal's decision in Barnes. That decision meant that many shared student houses would fall entirely outside the ambit of the legislation because they would not count as HMOs at all. The 2004 Act, very deliberate and detailed provisions, which Mr. Arden showed you, defining who counts as a member of a household, ensure that there can be no question of students as a class falling outside the legislation. And likewise, Mr. Arden showed you the very specific provisions of Schedule 14, which tell you what kind of student accommodation falls categorically outside the definition of an HMO. But providing we're not dealing with accommodation in that class, the condition in issue here does nothing to take this accommodation outside the ambit of the legislation.
Just to clarify,
yes.
You say the condition in issue here.
Yes.
Can we just be clear which conditions we are now dealing with?
Yes.
Because there were additional conditions imposed by the court.
Yes, I should have said the conditions in issue here.
So do we find anywhere set out in one document the conditions which we're now dealing with?
We don't, I'm afraid, because what happened was this, that the first tier tribunal, there are two houses in these cases, and each house, the licence application in relation to each house was dealt with by a different constitution of the first tier tribunal. In respect of the first house, the first tier tribunals imposed a condition that the attic bedroom could only be occupied by a student. In the second case, the position was slightly different, but everyone has assumed that the intention was to impose a similar condition. The case then went to the upper tribunal, and the upper tribunal varied that to some degree, but then the Court of Appeal...
But we have at page 168 the upper tribunal's condition.
Yes.
Relating to second floor front bedroom.
Yes.
That's still live, is it?
Yes, it is.
And then
what the Court of Appeal did was that it then imposed an additional...
Yes, we then have on page 148 the further conditions by the Court of Appeal.
That's right.
So are we to assume that we now have three conditions, the one on page 168 and the two on page 148?
Yes.
That they apply to both properties?
Yes. That's my assumption anyway.
If anyone disagrees with that, they'll no doubt tell us.
So the conditions in issue, my point is quite a simple one. It's that the conditions in issue here do not take these houses outside the ambit of the HMO regime. They don't take student accommodation generally outside the ambit of the legislation. These houses remain HMOs and they remain subject to inspection as such in precisely the same way as if the condition had not been imposed. Now, it was suggested, I think, at one stage by Mr. Arden that the effect of the Court of Appeal's construction was that somehow this class of accommodation would become unregulated. In other words, that we would be returning to the position as it was when the Court of Appeal looked at the predecessor provisions in the case of Barnes. But if you have the first tier tribunal judgment in this case at MS 175 and following, as I said, there are two FTT judgments, but just taking the first, the second one adopts almost exactly the same reasoning as the first. So if one just looks at the findings at 175 and following, what one sees from this is, far from the position being unregulated, there is here a very careful consideration of the particular characteristics of this house and whether it would or would not be suitable for the given number of occupants, namely 6. And one can see at 22, the tribunal looks at the respondents, that's to say that the council's guidance and the stated minimum floor space in that guidance. But it makes the point that that is just a recommendation and it has to be applied flexibly. Then it looked at 23 at the particular characteristics of the relevant room, and it made the point that although some of the floor space in the room is under a sloping roof, you shouldn't ignore that space completely because it could be used for certain things, so it wasn't totally irrelevant. So it's quite a detailed consideration of the characteristics of this accommodation. And then over the page at 24 and 25, it makes the point that the living accommodation is bigger than the recommended minimum, and that may be properly regarded as a compensating feature in a case, see paragraph 28, where the mode of occupation is cohesive. So the tribunal then finds that the relevant room at 28 is adequate as a study bedroom where cohesive living is envisaged. And if one can answer the question, well, why is that? It's because where cohesive living is envisaged, the extra space that's available in the living room counts, because that room is going to be used, or the assumption is that that room is going to be used communally. Where cohesive living...
Or it can be in any event.
Or it can be, exactly.
If you choose not to go and use the kitchen
for you.
And microwave your own meals in your own room, well, that's one thing, that's for you.
Yes, exactly.
But Mr. Chamberlain, before we leave this
yes.
FTT decision,
yes.
I know this is more relevant to the second issue. Where is there a detailed analysis of, now look, we need cohesive living here. We can properly decide that students cohere. Where do they do all that?
Well, Your Lordship will not find a passage in the FTT's judgment where they give reasons for that. And I'll come to deal, when I look at rationality, with what's the proper approach to that. There are two ways you can do it. One is to say, well, they're applying their own knowledge of the local market. So it may be that students in some areas do tend to live cohesively and students in other areas tend to do so less. So this was an expert tribunal. A surveyor went round with the FTT legal member, and they reached a view that they impliedly reached a view that students live cohesively, generally speaking. Now, if you come to the view that's just not good enough, and one would need to see some kind of further reasoning to back up that assumption or to justify it, then there are other ways that can be addressed, for example, by imposing the alternative condition suggested by Upper Tribunal Judge Roger, which was a condition that the house be let only to those who are intending to live cohesively. And I'll show you yet another way that it could be addressed and is addressed in one local
authority. You don't
authority.
find what I was looking for here.
No.
Very well.
Whilst you pause, can I just ask for a bit more information? They are working on the basis of over-provision in the living accommodation. Yes. The guidance requires kitchen and dining space up to a certain minimum, is that right? But no living space.
That's right. So you wouldn't even have to have a separate living room, according to the guidance. And essentially what they're saying here is if you do have a room that's set aside for communal living, then that is going to be of use to you if you are the sort of person who engages in communal living. If you're not, it's not going to be of use to you. And therefore, it wouldn't, in the latter category of case, be capable of compensating for a shortfall in the bedroom. Essentially, that's the structure of the reasoning. Now, the appellant says, and again, it's at paragraph 28 of its case, that no doubt the intention was to allow occupation at a lower standard or by a greater number than would otherwise have been permitted. And Mr. Moffat for the Secretary of State made that point in his oral submissions as well. The key is, he says, this interpretation, the Court of Appeal's construction of this provision, allows for occupation at a lower standard. Now, plainly, the conditions imposed here allow occupation by a greater number than would otherwise have been permitted, but it does not, with respect, follow that the intention or effect was to allow occupation at a lower standard. The imposition of a minimum floor space requirement is designed to ensure that each occupant has available a minimum usable space. If the occupants are not going to live communally, then the usable space all has to be in the occupant's own room, leaving aside the kitchen diner, which is specified. If they are going to live communally or cohesively, then some of the usable space can be in the communal room. Another way of putting it is that the mode of occupation determines whether the living room is going to be of any benefit to the occupant. If the mode of occupation is not communal, the parts of the house set aside for communal use are of very little use. They may as well not be there, so far as the occupant is concerned. I mean, if one takes a very extreme example of people who are living hermit-like in their individual units, and they are told, well, here's a living room which is available for communal occupation, it simply isn't of any use to them. Obviously, there will be gradations and degrees within all of that, but conditions of this kind have got to deal with the general rather than the particular. Now, for that reason, in my respectful submission, there is nothing to suggest that 6 persons occupying communally will end up with a lower standard of accommodation than would 5 occupying non-communally. The 6 may in fact have a higher standard of accommodation because they will have available a generous communal living room where they may spend much of their time. So that deals with my first head of submissions under issue 1. The second head of submissions deals with the common practice before the 2004 Act, which, as I understand it, remains common practice, to take mode of occupation into account in deciding whether an HMO is suitable for a particular number of occupants. Now, Mr. Arden in his submission said, well, we can just ignore the amenity standards guidance, which I've referred to, set out by the Institute of Environmental Health Officers, because that's dealing with a predecessor statutory regime, and so it's irrelevant here. We say it's relevant because it shows what the practice was at the time of passage of the 2004 Act. And in any event, the practice remains reflected in the guidance of at least a number of local authorities to this day. Now, as Mr. Arden said, when preparing the case, I found the guidance on the website of the Chartered Institute of Environmental Health. But when the question was posed to me, where did you get that from? It wasn't there any longer. And I'm afraid I have no idea at all why. What can be said is that many local authorities, as I've said, do apply in their own guidance, either implicitly or explicitly, the same distinctions that one sees, and indeed sometimes even the same terminology that one sees in the 1994 note. So can I ask your Ladyships and your Lordship to look at the 1994 note. It's in Authorities Bundle 4, tab 48, MS 1683. And you can see that its title is a professional practice note by the Institution of Environmental Health Officers. That body is now known as the Chartered Institute of Environmental Health. Over the page on 1684, one can see what the Institution of Environmental Health Officers is. It's a professional body dedicated to the promotion of environmental health and to encouraging the highest possible standards in the training and the work of environmental health officers. It has approximately 8,500 members, most of whom work for local authorities in England, Wales and Northern Ireland. Presumably there's a separate one in Scotland. Apart from providing services information, it also advises government departments and is consulted by them on any proposed legislation relevant to the work of environmental health officers. If one goes over to 1686, the forward indicates that the point of this guidance is to reflect the fundamental belief of the institution that every household should have access to a house of a size, type and standard and in a location suitable to its needs. And then over the page at 1687, paragraph 1.03, one can see that HMOs come in all shapes and sizes, and there's perhaps no such thing as a typical HMO. For the purposes of this note, however, they're considered in a number of groups, having regard to various common characteristics. Over the page, you can see it's hoped that in time these amenity standards will give rise to a national standard, but ultimately it's for local authorities to set local standards and apply their discretion in every case. And then at 1.06, you can see the categories, and the key point for here is to look at categories A and B. Category A comprises houses occupied as individual rooms where there is some exclusive occupation and some sharing of amenities, brackets, bathroom and or toilet and or kitchen. But then this key sentence, each occupant lives otherwise independently of all others. And then category B are houses occupied on a shared basis. These would normally be occupied by members of a defined social group, e.g. students, or a group of young single adults. The occupiers each enjoy exclusive use of a bedroom, but would share other facilities, including a communal living space. So here is the Institute of Environmental Health saying there are two categories of occupation and different standards apply to each, as we'll see. Now, at 1.07, one can see that it's impossible to anticipate every variation on the HMO theme, and as before, it must be appreciated that the lines between the categories are to a degree arbitrary, but it is felt, see the last part of the last sentence, that core standards based on the categories above should be capable of being developed from the models offered. If one then goes forward to MS 1692, 2.01, one can see there that the recommended minimum floor space differs depending on which category of HMO you're looking at. So where you're dealing with a category A HMO, where each occupant lives independently of the others, save for sharing bathroom and kitchen facilities, the minimum is 13 square metres, where the unit includes kitchen facilities, or 10 square metres where it doesn't. And then if you just go forward then to MS 1700 and look at the equivalent for category B houses, one can see category B houses are those where the occupants share a communal living space. The minimum recommended is 10 square metres, except where a separate living room is provided, which is not a kitchen or kitchen diner, in which case the bedroom shall be 6.5 square metres. So different minima, different standards applicable depending on the mode of occupation. Now, why is this? Well, it is not, in my submission, because these standards contemplate a lower quality of accommodation for those occupying communally, but because communal areas count towards usable space for those occupying communally, but not for those living separately. To take another example, on MS 1698, you can see that for category A HMOs, each unit is to have a wash basin. Well, one can immediately see why that is. Where everyone is living independently, there needs to be a wash basin in each separate unit. But if you then look at 1705, paragraph 2.02, you can see that that condition is relaxed in category B HMOs, at least in cases where there is a bathroom on the same floor that's not shared by more than 3 people. Again, another respect in which mode of occupation is relevant to the suitability of a particular HMO for a particular number of persons. Now, the practice of distinguishing between HMOs in category A and HMOs in category B appears to remain quite common, not invariable, but common among local authorities. And you can see this from a note that was prepared by counsel for the respondent in the Court of Appeal, and that is at MS 485 in the core bundle. And what he did is...
Sorry, Mr. Chairman, 1845.
I'm sorry, it's core bundle MS 485.
485, thank you.
What he did was he took, you can see this from the opening words, he took the Russell Group of universities, as being a group of universities. He stripped out the London universities because accommodation was unlikely to be in the same borough as the university, and he stripped out the Scottish ones because different legislation would apply there. And he looked at the published guidelines of each local authority where students would be likely to live that went to the universities in the Russell Group. And he set out in this note what its guidelines say. And what this note shows, I'm not going to read it all out, is that many of these, in common with the 1994 Institute of Environmental Health Officers standards, adopt different minima or different standards for occupation depending on whether the occupation is communal or not. And that is the case for Birmingham, Durham, Exeter, Leeds and Southampton. And in each of those cases, the local authority's guidance refers specifically to students as an example of the type of occupant likely to occupy communally.
Yes, sorry, this is counsel Mr. Fuchs.
Yes,
Yes, in the Court of Appeal.
yes. That's where it came from.
And this is an analysis of the universities running, in effect, their halls of residence.
No, it's an analysis of the guidance issued by the local authorities for areas where students attending Russell Group universities would be likely to live. And one can see from each of these that there is reference, in some cases there is in fact reference to Category A, I think, and Category B houses. If one looks at Exeter, for example, on page 487, one can see the following said: many HMOs in Exeter are shared house HMOs. A shared house HMO is one where, although they're unrelated to one another, the occupiers live in a similar way to a family. Typically, the house has been rented by an identifiable group of sharers, such as students or work colleagues. Each occupant has his or her own bedroom, but they share the other facilities. And one can see, I don't know whether this was in bold in the original or whether Mr. Fuchs put it into bold, but there is usually a significant level of social interaction. And one can see we've adjusted our standards as they apply to shared house HMOs to make them more suited to the type of living pattern occurring in these properties. Look out for references to shared house HMOs as you read the standards. And then one can see a particular room size, minimum floor area specified for HMOs in that category. And just above, you can see Durham, the Durham local authority specification, which actually refers in terms to Category B houses, and that is obviously a reference back to the Institute of Environmental Health Officers categories that you have seen. Same for the University of Leeds over the page at 488. Now,
do we know the date of the information which this note is based on?
All I know is that, I understand it was current at the time of the Court of Appeal hearing.
It was done in preparation by Mr. Fuchs.
Yes, so it's
current.
We assume it was current. Then.
Yeah. So I mean, I should say I haven't redone the exercise that Mr. Fuchs.
No, well, I mean the date doesn't matter much. It's March 17, which would be good.
I've assumed that it's correct. Now, I've noted in my case that the amenity standards applied by the appellant, Nottingham City Council, follow the 1994 amenity standards in at least one respect, and that is that they provide, and one sees this from 461, MS 461, that occupants, in HMOs where the occupants tend to live separately, each unit must have its own wash basin, but not otherwise. So there's one small respect in which even the appellant agrees or appears to agree that mode of occupation can be relevant to suitability. Ladies, my lords, can I move then to my third head of submissions, which is section 64 and the purpose of conditions. Now, during the course of argument, Lord Wilson suggested that it might be argued that section 67 should be read as ancillary to section 64. Mr. Arden and Mr. Moffat both declined to adopt that suggestion, and I would say with respect that they were right not to do so. But section 64 is relevant to the construction issue. For this reason, just ask your lordships, your ladyships, to turn up that section. It's in Bundle 1, Tab 1. And one can see from 64.3a the matters to which the local authority is obliged to have regard are A, that the house is reasonably suitable for occupation by not more than the maximum number, or that it can be made so suitable by the imposition of conditions under section 67. Well, what does that show? It shows, in my submission, that at least one purpose for which a condition can be imposed is to make a house suitable for a particular number of individuals when it would not otherwise be so suitable. Now, take as an example a condition that a particular bedroom, let's say a small attic bedroom, can be occupied, but only by a child under 10. Now, there is no reason in principle why such a condition should be regarded as objectionable. It may be perfectly suitable for a child under 10, but not for an older child or for an adult. And as we've seen, the Secretary of State's own regulations, which have now been made and come into force on the 1st of October, specify different minimum floor space requirements for children under 10. Now, imagine just for a moment that a condition had been imposed in respect of a house in multiple occupation with a small attic bedroom, saying, yes, fine for a child under 10. Now, that is, of course, a condition regulating the class of occupier who can occupy a particular part of that house. Now, if you have a room that is suitable for occupation by a child under 10, but not suitable for anyone else, then the imposition of a condition limiting occupation to such a child will make the house suitable for a greater number of persons than would otherwise be appropriate. That's what it will do. Here is a house that can be occupied by 5 people if one of them's under 10. If none of them are under 10, it can only be occupied by 4 people. What is wrong with such a condition?
Clearly, my suggestion about an immutable link between section 67 and 64 was wrong. Mr. Moffat knocked that on the head by drawing our attention to 67(2)(b). But would you nevertheless concede that the conditions imposed here by the first-tier tribunals were in aid of making the houses reasonably suitable for occupation by no more than the maximum number stipulated for the purposes of section 64(3)?
I think I would, actually, yes. And lots of conditions will qualify as conditions in aid of. So I'd agree with Mr. Moffat that this was a condition which enables the house to be suitable to be occupied by a larger number of occupants, and that will be true of many conditions, including the example I've just given.
I mean, the difficulty could be that it's not making the house suitable for that occupation. It's making the obvious sort of things, as if you look at 67(2)(c), conditions requiring facilities and equipment made available. Well, they're doing something to the property to make it suitable for a great number of people. In your example, the house is in itself suitable for occupation for a family which has a child under 10. The purpose of the condition is not to make it suitable, but to enforce that particular requirement. And it just seems to be slightly odd that if Parliament was intending to have that sort of purpose, that it wasn't done more specifically.
Well, I think my answer to that, my Lord, would be that analytically there's no difference between a condition saying this bedroom can only be occupied by somebody under 10 and a condition saying this house can be occupied by 5 people as long as they're students. They're both conditions.
No, I understand that, but it seems to be neither of them arguably fall naturally within the words of that section. I mean, we were referred by Mr. Arden by comparison to the earlier section 22(5), dealing with prohibition orders, and there you have a clear provision which enables to impose a prohibition on occupation by particular descriptions of person. And that would clearly cover the sort of situation we're dealing with here.
Yes.
He says, well, is rather notable by its absence from section 64.
Well, I'm going to come to, when one's asking the question, what can you do with a condition? That question is answered by section 67. So this section 64 is telling you for what purposes can you impose a condition. And one of the purposes for which you can impose a condition, not the only purpose, but one of the purposes for which you can impose a condition is to make a house suitable for a particular number of people. But it follows from the fact that that is one of the purposes for which a condition can be imposed, that were it not there, the house would be suitable for a lower number, perhaps not suitable for any occupants. And I would say that when one looks at the language of section 64, it is very difficult, once you accept that a condition can regulate class of occupier, as Mr. Moffat does, it's very difficult to then say that, but it can't make the house suitable for a greater number of occupants than would otherwise be appropriate, because there's nothing in section 64 to indicate that kind of distinction being drawn. You've got to ask yourself the question, with the condition, is the house suitable for a particular number of people? And that's really the only question you have to ask. And if you've answered that question in the affirmative and you've said, yes, with the condition, the house is suitable for 5 people. It doesn't matter whether the condition is that room can only be occupied by a child or all the occupants have to be students. With the condition, the house is suitable for the relevant number. Without it, it's not.
And I suppose we have these examples of other university authorities which apparently recognise the distinction between common living by students and others.
Yeah.
We don't know what legal mechanism they use to secure that, do we? Because it's difficult to see anything else other than section 64(3 which does the trick.
No. Well, maybe that Mr. Arden is able to point to some, but I'm certainly not. And Mr. Arden's answer to that is, well, it's fine for local authorities to take into account the actual mode of occupation of the house in considering suitability. And my response to that would be, well, if it's fine for local authorities to take that into account on the question of suitability, why on earth can't they impose a condition to enforce that? So his answer was, well, they could take it into account by varying the license at a later stage if the occupation changed. But I think this was in response to a question by Lady Black, what's happened here, and you can see this from the first-tier tribunal decisions, is that the first-tier tribunal has said, well, this is a 5-year licence. I know that the people who are currently occupying are students and living cohesively, but I want some assurance that that will remain so for the rest of the 5-year licence term. And if mode of occupation is in principle relevant to suitability, why shouldn't they do that? Now, as I've said, the Secretary of State differs from the appellant in conceding in principle, I would submit correctly, that Section 67 of the Act authorises the imposition of conditions restricting occupation to a particular class of person. Mr. Moffat's argument is that even so, such a condition cannot be used to enable occupation by a greater number of persons than would otherwise be appropriate. And I would say that is quite a difficult argument to sustain when you look at the language of section 64(3)(a). Once you accept, as Mr. Moffat does, that a condition can regulate the class of occupier, it follows from the wording of section 64 that it can, in principle, make the house suitable for occupation by a greater number than would otherwise be appropriate. Can I turn then to my fourth head of submissions, and that's the pre-legislative materials and the terms of section 67 itself. I start from the proposition that by 2004 it was common practice, even if not invariable practice, to treat mode of occupation as relevant to judgments about suitability. Against that background, it's relevant to consider whether the pre-legislative materials disclose any intention or indication that that practice had been identified as problematic, or any intention to reform it. Now, both Mr. Arden and Mr. Moffat took you to the 1999 consultation paper, and one of the things that that consultation paper does is it identifies the Barnes decision as problematic, because there are 9 indicia that you have to apply, and nobody's going to know in advance whether a particular house is an HMO or not. And as a result of that, local authorities, so the consultation paper says, paragraph 23, are wary of using their powers in relation to shared houses occupied by students. But aside from that, and of course that problem has been addressed in the Act. It's been addressed by the specific provisions that define who is a member of a household. And they define it with great particularity by reference to particular familial relations. But there is nothing aside from that to indicate that it was regarded as problematic to assess the suitability of a house by reference to the type of occupier. Nowhere in that consultation paper does it say the current practice, which we know that some local authorities at least adopted, of treating houses occupied communally in a different way from houses occupied non-communally, was a problem. And so there is nothing in the pre-legislative materials to indicate any intention to reform in that respect. Now, section 67 is at MS 634, and in my submission, its terms may be thought to support a power to impose conditions regulating the class of occupier. And there are 3 points here. The first is that section 67(1) confers power to regulate the management, use and occupation of the house concerned, and the natural reading is that occupation must be something different from use. On its face, the concept of occupation is apt in my submission to include both how and by whom the house is occupied. Second, if that is right...
Mr. Arden, I should have put this to Mr. Arden.
Yes.
So I'm putting it to you so that he can think about it.
Yes.
Find out the answer by the time he gets on his feet again. Had use and occupation been a composite term, would one have expected to see the word "and" between management and use?
Yes. Well, I would respectfully...
Just occurred to me. Anyway, it's a thought.
I would respectfully adopt that. But there's also the point that was made in argument by Lady Black, which is that when one looks at 67(2)(a), the words are use or occupation, and that does suggest, that disjunctive form does suggest that the two concepts are intended to be separate. And it's not to say there may not be some overlap, maybe there is some overlap, but that in principle the two concepts are intended to be separate. And of course, one accepts, Mr. Arden referred to Benyon, that in principle you can have a phrase of that kind that refers to a single concept, but the indication here is that it doesn't. So that's the second point. The third point is that the remainder of section 67 tells us both what conditions the licence must include, C67.3, namely the ones in Schedule 4, and what conditions it may not include, see section 67.5 and 6. Now, if Parliament had wished to stipulate that conditions could not be used to regulate class of occupier, it could easily have said so. And that, in some ways, is an answer to the point that Lord Carnwath put a moment ago, which is, well, when you look at the contrast with section 23, you don't see Parliament expressly authorising the imposition of conditions to regulate class of occupier. Well, I suppose one riposte to that might be you also don't see Parliament expressly precluding it, and you do see Parliament expressly precluding certain other things in relation to conditions. So can I move to my fifth head of submissions? Those are and that's to do with the statutory mechanisms for imposing minimum standards applicable to all HMOs. Now, we've seen that there are two specific mechanisms for imposing mandatory minimum standards. First of all, there is section 65, in particular, section 65.3 provides that in this section prescribed standards mean standards prescribed by regulations made by the appropriate authority. So there is a power under which the 2006 regulations have been made, and those deal with heating, washing facilities and kitchens, and they specify different minima for units of living accommodation without shared basic amenities. The second mechanism for imposing mandatory minimum standards is contained in Schedule 4 to the 2004 Act, and that specifies on the face of the Act certain mandatory conditions that must be imposed. And in paragraph 3, it confers a power to amend the schedule to add or remove conditions. Now, the 2018 regulations were, at the time of putting in our printed cases, still in draft. Mr. Arden tells me, and I accept from him, that those regulations have now been made, albeit they don't come into force till the 1st of October. But those regulations, when they do come into force, and you have them in Authorities Bundle, perhaps we'll just have a quick look at them, if we may. In Authorities Bundle 1, tab 19, and you can see that they specify mandatory minimum floor space requirements, which differ depending on whether the occupant is over 10 or under 10. Now,
will it, as a matter of interest, knock out the ability for the attic bedroom in Rothsay Avenue to be used?
yes.
Yes?
I believe it will. And so, Lordship knows I don't come here with any brief for the landlord in this case, but obviously the point of principle is important,
yes,
because the next attic bedroom may be of a different size. But the existence of these mandatory minimum standards is, in my submission, relevant for this reason, that they are Parliament's way of providing for the imposition of generally applicable minima where that is thought appropriate. And that's relevant to the question of construction before you because it provides the answer to the suggestion that the Court of Appeal's interpretation can lead to an erosion of standards below acceptable minima. And it's also relevant because it obviates the need to adopt an inflexible one-size-fits-all approach to the assessment of suitability in cases that do meet the prescribed minima. So in other words, if there is, if I can put it perhaps in these terms, if Mr. Arden's submissions might be thought to raise the spectre of first-tier tribunals authorising, or local authorities indeed, authorising the occupation of accommodation which is simply substandard, there is a flaw. There's a statutory mechanism for a flaw to be set, and these regulations are a good example of that mechanism being used by the Secretary of State, subject to parliamentary approval, to prescribe the relevant minima. But they're relevant for another reason as well, and Mr. Moffat didn't accept this, but in my submission, when you look at the different standards that apply depending on whether someone is over 10 or under 10, that is an example of suitability depending on the class of occupier. Now, plainly, it's a different class, but it is an example of suitability depending on class. And of course, it's right for Mr. Arden to say, well, there's a specific authorisation, as there always has to be when a statutory instrument is in play, for different classes of individuals to be dealt with in different ways. Otherwise, the instrument will fall foul of public law principles dating back to Cruz and Johnston and other cases like that. But when one is asking the question, is there some fundamental principle that one can derive from the statute that says all judgments about suitability must be applicable to every occupant? The fact that this instrument, with statutory authority, distinguishes in this very obvious way between two classes of occupant, in my respectful submission, may be thought to give the lie to that submission. So can I move then to my sixth head of submissions, which is a very brief one before going on to issue 2. And that is that the appellant's construction may operate to the detriment of students by driving up costs. And if we go back to my first submission, which is that the conferral of a power to impose conditions regulating class of occupier does not necessarily lead to the relevant class having to endure substandard or less or a lower quality of accommodation. What you do if you impose a restriction preventing the imposition of any such condition by reference to class of occupier is you drive up the cost for that class of occupant beyond the level required to achieve suitability for that class. In other words, you are saying to students, there is a category of house which, in the expert opinion of the first-tier tribunal, would be suitable for you, but you can't have available to you that category of house. You must live in a more expensive one. I say more expensive because it must follow that will be so in circumstances such as this.
It may not just be more expensive, it may be unavailable.
Indeed, that's the other side of the same coin, yes. if one assumes that price and supply and demand are linked in the normal way, that is the other side of that coin. And obviously cost considerations, I hope I can be forgiven for saying this without pointing to any evidence of it, are likely to be quite important for students as a generalisation. So that's issue one, the issue of construction. Can I deal then with issue two, which, as I said at the outset, is a rationality challenge? Now, it's plain that class of occupier, as I've shown, can sometimes be relevant to suitability, even though there is a great deal of variation in the class. Take, again, under 10s and over 10s. Again, I hope I can invite the court to take judicial notice of the fact that members of the class of under 10s differ very substantially one from another. But it is still appropriate to apply the same general standard to all members of the class because, in general, under 10s will need less space than over 10s. Now, what is that? It is a generalisation. Here, the tribunals below treated membership of a class, students, as a proxy for a particular mode of occupation, communal or cohesive occupation. The question whether it was appropriate to do that is a question of fact, subject, of course, to the point about reasons which my Lord Wilson put to me at the outset. And the answer to it may, in principle, differ from one location to another. It may be that students in a particular university, particular town, tend to live in one way, and students in a particular location tend to live in another. That means, in my submission, that the caution that this court normally applies when considering findings of fact by specialist tribunals should apply here. And I've set out in my case at paragraph 51.1 the well-known passage on that subject from Lady Hale's speech in AH Sudan, at paragraph 30. That's at Authorities Bundle 2, tab 20, MS 884. Now, if the court takes the view that the generalisation underlying the conditions in this case is not appropriate, it may be appropriate to consider a more tailored condition limiting occupation not to students, but to a group who intend to share the communal living space. Now, I've formulated it in that way because that is the alternative condition that was identified by Upper Tribunal Judge Roger QC at paragraph 31 of his judgment. I'll just show you that. It's in the core bundle at MS 167. And it's at paragraph 31. And this is what he says. He says, I'm satisfied that there's nothing unlawful in a condition restricting the use of sleeping accommodation in part of an HMO to a person in full-time education if the decision maker is satisfied that looked at as a whole, the HMO is suitable for the number of households specified in the licence. An alternative condition, perhaps more closely reflecting the reason for permitting the use of a room smaller than would normally be acceptable, might require that the occupiers be members of a group who intend to share the communal living space. But I do not think the reference to students makes the condition unlawful. Now, to come back and pick up a couple of questions that were put in the course of argument by Lord Carnwath this morning, by reference to the analogy with planning conditions. What one is doing when one imposes a condition is not achieving perfect symmetry between those who satisfy the condition and those who exhibit the characteristics which the condition is sought to model or to reflect. It is this was an attempt by the first tier tribunal to produce a practically understandable and enforceable condition which reflects its reason for thinking that a smaller bedroom was appropriate. It was a generalisation, and there's no doubt that in some cases the generalisation will not be borne out. But what the upper tribunal judge is doing here is saying, well, it was a good enough generalisation. I say that is a question, for this court, that's a question of rationality. Was the first tier tribunal rationally entitled to conclude that the generalisation was a sufficiently good proxy? If not, says upper tribunal judge Roger, an alternative condition would be one permitting use of the room, subject to the condition that the occupiers be members of a group who intend to share the communal living space.
But
one has to add to that.
Difference, Mr. Chamberlain, that there should be a living room.
Yes.
And that it be shared by a cohesive group.
Yes.
Why ban the occupant of the attic from living there for more than 10 months?
Well, he deals with that at the end of his judgment, and he says, well, if there is a problem with the 10-month restriction, and he suggests, he doesn't deal with it in great detail, but he says if there is a problem with the 10-month restriction, I'd delete it.
Well, are you submitting that there is no problem with that restriction?
Well, my lord, I see the point, the force of the point that your lordship puts to me, that if the room is not suitable for occupation for more than 10 months, why, if it's not suitable for occupation for 12 months, why is it suitable for occupation for 10 months? Mr. Arden, in my respectful submission, was correct to identify that condition as effectively another way of ensuring that the person who occupies is a student. So that's essentially what that condition is doing. It is saying, again, it's a generalisation, students tend to occupy student accommodation for no more than 10 months. So I'm going to impose the 10-month condition to make sure that the person who occupies is a student. So if your lordships and your ladyship come to the view that that is an inappropriate condition, you should do what Upper Tribunal Judge Roger would have done, which is just delete it. It's not necessary.
If that's all it's doing, you don't need it to.
Yeah, exactly. Exactly.
It doesn't achieve anything.
No, I agree. So no, I don't have any further more sophisticated defence of the 10-month condition than that, I'm afraid. So the alternative condition is set out there. Now, there is a further alternative which arises from the approach of Birmingham, and I'll just show you that. It's back in the note produced by Mr. Fuchs. If you go to MS 485, you can see this in the local authority guidance from Birmingham. It's recognised that many houses which are used to provide shared accommodation for students may have one bedroom which is marginally below the required floor area of 6.5 square metres. In such cases, it is acceptable to allow for up to 10% shortfall in floor area, subject to the following conditions. Then you can see the first one is the occupiers must have approached the landlord / managing agent as a group wishing to rent the house under the terms of a joint contract. Now, what that is doing is it is picking up one of the indicia which you'll have seen in Sir Thomas Bingham's judgment in the Barnes case. In other words, it's saying people in that kind of a group tend to occupy cohesively or communally, and if that condition is satisfied, then we are happy to allow a shortfall of 10%. It's another way of achieving the same purpose as the FTT and Upper Tribunal had in this case. So the short submission is that if the court were to come to the view that the particular conditions imposed here were not a good enough proxy for mode of occupation. That is not to say that there might not be some other condition, such as this, or such as the one proposed as an alternative by Upper Tribunal Judge Roger, which would be a better proxy and would better achieve the effect which was sought to be achieved.
Is it being said that that should be opposed as a condition under Section 67?
Well, I don't know if it's being said, but but there's nothing to stop it from being so.
It says subject to the following conditions.
Yes.
I don't know what it means by that.
Well, it's not clear from the extract whether they meant that that would be imposed by a condition under Section 67, but my proposal, picking up what's said there, is that it could be. There's no reason why it couldn't be imposed as a condition under Section 67. What both that condition and Judge Rogers' condition have in common is that they are enforceable because it's a condition which has to be satisfied at the outset. This is a group which intends to live in a particular way, or which has a characteristic at the point where they take on the tenancy that indicates that they intend to live in a particular way. And if one allies that with the condition that the Court of Appeal imposed, the additional condition the Court of Appeal imposed, which is that the living room must be available for communal use, then one has a sufficient set of conditions taken together to achieve the effect that's intended. Now, finally, there is the appellant's objection to the suitability of both the requirement that the occupiers must all be in full-time education and the maximum 10-month residence requirement on grounds of enforceability. So the point that my Lord put to me about the 10-month residence requirement was, well, it's objectionable in principle, because if it's not good enough for 12 months, why should it be good enough for 10? I hope I've dealt with that and said that if your Lordships and your Ladyship come to the view that it's an in principle objectionable, you can just delete it. This is a separate objection. It's an objection to enforceability, and it's put both to the 10-month residence requirement and to the requirement that the occupants must be in full-time education. And the answer to that I can give very briefly, that the caution appropriate before interfering with the decision of a specialist tribunal is especially pertinent when considering the quintessentially practical issue of whether a condition is enforceable. In any event, as Lord Justice Lewison pointed out, why should it be more difficult to ascertain or prove whether someone is in full-time education than it is to ascertain whether a house is his main residence? And the significance of that is that, of course, the question whether a house is your main residence is one of the issues that has to be considered in deciding whether the regime applies at all. In any event, if the particular conditions imposed here are, as the appellant says, unenforceable, the solution may be to delete or redraft them.
I'm still trying to get my head around what the actual test is of legality or rationality.
Yes.
Because, again, I'm sorry about bringing in planning, but there have
Yes.
been quite a lot of cases on planning conditions.
Yes.
And it's generally accepted the mere fact that the condition isn't perfect or isn't enforceable in every situation doesn't make it invalid or irrational.
Yes.
Whereas if it's wholly unenforceable, then that may be a factor. Is there, what would you say the test is?
Well, I would respectfully accept the analogy, because one of the points made, for example, by Mr. Moffat this morning was, well, if you impose a condition which is designed to catch a group of occupants who live cohesively, you've got no guarantee that they will, in fact, live cohesively. And the answer I would give is precisely the answer that my Lord tells me is given in planning cases, which is, well, Of course, there is no guarantee. It's a pretty rough and ready business, imposing conditions. You impose it on the basis of a generalisation that a particular class of individuals is likely to occupy in a particular way, and you have no guarantee, but you don't need one because there are other statutory mechanisms by which you can ensure that you don't fall below a minimum acceptable set of standards. And so even if a small shortfall in, for example, floor space is permissible, you're not going to fall below the specified minima, and you're not therefore going to have a situation where the accommodation is so far below acceptable standards that a difficulty arises.
For its worth, I dug up from Bailey an extract from a recent judgment of Mr. Justice Jay, which says, conditions which are not enforceable in practical terms are unlawful, see Rochdale, ex parte Mills, Sullivan J. But those which are merely difficult to enforce are not, see Bromgrove, DC, 1988 JPR. I have no idea what those cases are about.
Just on that question, if one takes the condition that all the occupants have got to be in full-time education, there may be some difficulties in enforcing it, but it's not in principle unenforceable. It is ascertainable whether someone is, at a particular moment, in full-time education. You can get a letter from the university. You can see whether they're on the roll of the university. And so I think Mr. Arden at one stage was predisposed to accept that, at least in principle, that is an enforceable condition. It may be, again, whether a house has been occupied for more than 10 months a year is in principle enforceable. Maybe a little bit more difficult. You may have to supply evidence of whether rent payments have been made and so forth, but there is nothing in principle unenforceable about that condition. Ladies, lords, unless I can assist further, those are my submissions. I see I've taken a bit less than my 1.5 hours.
It looks as if everybody's asked you everything they want to ask you, Mr. Chamberlain, but we are very conscious that you're here as advocate to the court. You're not actually representing the respondents. They haven't told you what it is that they want you to achieve, and so if we ask you how to do a certain thing, it's merely your own opinion on that.
It is.
But we're most grateful to you. Thank you very much indeed. Thank you. Mr. Arden.
Lady. It's structured in a certain order, a good order. Taking first your ladyship's point about management, use and occupation. First of all, arguably that is the composite phrase.
But you would accept that management and use and occupation are separate things.
There's an overlap.
Oh.
There's an overlap in all of them. Secondly, I was never particularly, as it were, frightened of it. As I said, use goes to how an HMO is used and occupied, patient how it's occupied. A basement room may not be used for anything other than storage. Attic room may be used for sleeping, provided not occupied by more than one person, or so on. But what I do say in response to your ladyship is this. The fact that it may have a different meaning doesn't alter our submission and doesn't, in our respectful submission, undermine our submission. Though what is in issue is making a house suitable for occupation. You cannot do this by saying who occupies, only how it is occupied. And that is our, as it were, fundamental. It doesn't mean, because it has a separate meaning, oh, that does mean how it's occupied. That, at any rate, is what we submit in response to your ladyship's point. In response to the point that it could be detrimental to the interests of the class intended to be protected, it could make accommodation more expensive or unavailable. Yes, that's right. That's true of almost all protective legislation in almost every area of law. The Rent Acts froze supply, or were said to have frozen supply in any event. There's no doubt at all about that, and it is perfectly open to Parliament to nonetheless take the policy decision that it is setting a minimum standard. I'll come back to what I'm saying about standards. Minimum criteria, perhaps, might be the better word. Below which, or beyond which, or however you want to put it, accommodation is not to be occupied. And that is really, respectfully, elementary law in the area of protection of people. Does it sometimes mean accommodation is more expensive? Yes. Employment may be less because it's more expensive because of protective measures. We may find plumbers are less available. I don't think I was saying, certainly didn't intend to say, that students were now being taken out of the legislation. I hoped I was fairly clear that what I was saying was that the decisions allowed students to be treated differently in the sense that a greater number could occupy than others. I'm not resiling from that, of course. Whether that's a higher or lower standard is really sort of a subjective view. It's not about that. I call it lower standards, but I'm happy to paraphrase it by saying all I'm talking about is, as Mr. Moffat puts it very well, allowing more people to occupy than otherwise. No, it is lower standards in the sense that they're allowed to occupy a smaller room than otherwise. It doesn't matter how you put it. I'm not saying they've been taken out of the legislation, but I am saying that different standards are being applied. Now, we come to what was the longest part of Millennium Friends' submissions, and I really felt quite foolish for not having made this clear. I had hoped I'd made it clear. The difference between guidance and a condition, modes of occupation. I thought we were very clear in saying mode of occupation can allow a different standard. I thought I said that repeatedly. And what we said about the guidance is that that was describing circumstances where it may be appropriate to vary the standard. I'll try and not use the word lower. It wasn't saying it is always the case if there is a shared house. The guidance is guidance on when the authority may accept a lower standard. There's nothing, a varied standard, but it's nothing to do with conditions.
But I mean, why not? Why are you taking the point? Because we've seen these examples given in Mr. Fuchs's note of other authorities who clearly do draw the sort of distinction. And Mr. Judge Rogers' decision would have given them the ability not just to give guidance, but actually to put some teeth behind those differences.
Yeah.
What, from your policy point of view, what's wrong with that?
The point, and our central point, and it really is, the Act says, if I may paraphrase, people shall not live at lower standards than this Act sets. Shall not. Not may. We can have guidance and most will be covered, will meet the standard. They shall not live at a lower standard. That is fundamental to this Act. You can't have a condition based on how people are likely to occupy, because that also means that some won't. It has to be, Mr. Moffat also said this better than I did, it has to be actual, it has to be genuine, it has to be real. I mean, in one sense, you could say you can't have a condition requiring people to live cohesively. People either do or don't. And I'll obviously don't accept that students is a proxy. But I'm going to make what will sound like a concession, but I want to take it in stages. It's not a concession at all. I'm sorry, this one is one. Yes, it is. Sorry. In theory, we accept you could have a condition that the property, obviously this is going to be tied to a particular number. We don't need to go to the numbers point. It's obviously going to be a different number than otherwise. Have a condition that only to be let to or occupied by a group who intend to and will live communally. In theory. You have to have the will element, because without that you have intention, but as we all know, intention is one thing and actuality is another. You would still need, in our submission, to define in that communal living. You would need to define what was meant. You could not do it on the basis of likelihood, because, as I say, if it is likelihood, then some of definition will occupy who don't meet the criteria. And this Act is absolutely clear. No one, not one person in the country, is to live below its minimum. Its minima. It's not good enough with respect to say most people will be covered. They all have to be covered. That's why it has to be actual and genuine. Otherwise, you are departing from the clear wording and intention of the Act. It can't be done on likelihood. It can't be done without defining what is meant by communal. This would be the authority defining it in these circumstances, for their area, for their choice, or the tribunal. And of course we say it cannot be because they fall into a class like students, because there is no basis whatsoever for saying that all students live in a particular way. And as I think I've already said, it can't be done on intention, because there's no breach and no variation if people intended to, but we're not actually doing it. But we did intend to. Well, this is central to what we're saying. The Act does not allow anyone to live below certain standards. I hope you all appreciate what I mean by that. I'm talking about numbers, suitability, and so on. No one is to live below it. Therefore, it has to be actual.
Are you drifting towards inviting us to consider recasting the conditions?
No, because you don't have anything like the material on which to do it with respect. There haven't been the submissions, there isn't material below. I mean, it's all assumed that there was the material as to cohesive living below. There wasn't. Absolutely not. I said it would sound like a concession, but then when I qualify it, it isn't. I'm not saying anything different than I've said all along. Mode of occupation, I think I said it would be, it's common sense that there are different requirements depending on how people occupy. So yes, communal living could lead to more people, or could lead to the use of the small bedroom. We've always accepted this. Paragraph 29 from the local authorities submission that I read out to the first tier tribunal said that. You can't assume cohesiveness, but if it's actual and genuine, then yes, you could vary the standards. We don't think it is appropriate to make it a condition, because you're trying to make it a condition, because you can't make it a condition without defining what is meant by cohesive or communal. And I'm sorry, I really feel I'm beating I'm repeating myself too many times, but cohesive and communal living have very different meanings to different people. They're very subjective terms. And you can't have a condition unless it is defined. I'm going to come back to planning and flatter my face when I try and take issue with it, but I'll come back to planning if I may. Unless you define it, what is meant, you can't have it as a condition. You can't have it as a condition based on likelihood, because that means that some people will not occupy in that way. And that is what the Act prohibits. And if that is against the interests of the class, then that is a matter of politics, and that is what they can make submissions on when these things are varied. But that is fundamental to our argument. People are not to live below certain standards. So likelihood doesn't work. I deal briefly with the age of 10. Well, first of all, I've given an answer that I don't think it is purely legalistic. Section 250 on page 652, section 265 and 656 allow the Secretary of State to amend the Act, which is what is done, because it's a condition in the schedule, and to make provision for different classes, different cases. It explicitly authorises him or her, I think so far it's always been him, to draw these distinctions, as of course Parliament did, as it did between students, as it did between migrants, and other people. The Act makes lots of distinctions. So I can't just simply say because it's done one, therefore any other distinction can be drawn, because on that basis you don't even need 10 above and below. You've got migrants, you've got domestic workers, and so on and so forth, carers. But secondly on this, we do feel that there isn't an equiparation between class in the sense of above and below 10 and different classes of the population. Just because in one sense you can say, well, you could classify that as two classes, doesn't mean in every sense that you do so. We think it's a rather surprising analogy to draw, but in any event, it doesn't matter because the Act empowers it, because the Secretary of State was empowered to amend the Act with differences. And that is really our fundamental point then. It really it's turning it on its head to say, oh, well, now he has said 10. I mean, I suppose if we're right and that he didn't have those sections, we might be arguing about the vires of the order. It doesn't follow that because he's made it that he's right. But we think he was empowered to do it. But if he didn't have those powers and he made a provision drawing a distinction which was impermissible, then yes, one could come here and say it was ultra vires. My Lord, so just address some points largely I identify with Lord Carmarth. On planning and use, I did check, and as I think your Lordship probably knows better than I, there's very little actually in the Act about what plans are about, and it's been developed as policy, although economic and financial considerations are certainly valid. But it is certainly clear that the economic needs or conditions of an area are permissible planning considerations. And that, I believe, is what led to the rural workers, because you needed, agricultural workers. But the breadth of permissible consideration in planning law is vast. It's not part of HMO law that they can make conditions based on the economic considerations of the area. So we'll start saying you must let this to, I don't know, workers of a certain sort because we want them to, be employed in our factories. And turning it upside down, you can't start saying we won't let it be let to homeless people because we don't want them in the area. And that wasn't a fantasy example, the latter. Homes for Votes was about that. But my point is, we've said, and we stand by this, and if we're wrong on this, we accept that Section 67 is not tied to Section 64, we accepted that. But it isn't completely at large, and we've submitted that the conditions must be such which in some way affect the suitability of the accommodation. Not necessarily for number, but which go to the suitability of the accommodation as an HMO. And therefore, we respectfully reject that example. Unenforceable, we have never said you can't enforce whether somebody is a full-time student is not something you can prove. We have never said that. We accept that that is one of the easiest things to establish. What we said on full-time students was the technical body I didn't go into about whether you can actually evict anyone. So you've got a group of people, one of them ceases to be a student, fails their exams maybe, has to resit next year. They've got a 2-year lease. It's got a requirement that they're all students. They go to the court says, the court's not going to evict people, they're not going to forfeit the lease, because that's the sort of point we made about enforceability. You couldn't actually enforce it because the landlord can't evict in practice. That was the point. It's very much the bottom end point, it's hardly.
The enforcement mechanism is Section 72, is it?
Yes, but if the landlord's got a reasonable excuse, you can't.
No.
He's got a defence. So if he can never evict people because they cease to be students, then that condition ceases to have any effect. But it's so much the tail end point in all this that the far more important point to us on enforceability was that we simply cannot enforce 10 months over the year. Check on them every weekend. It is absolutely off the map in terms of what the authority can do. And it's not equivalent to copying it.
I'm slightly more troubled about who you enforce against. If you take the Deputy President's condition, the second floor bedroom may only be used for sleeping accommodation by a person engaged in full-time education and so on.
Enforce against the landlord because he is allowing it to be occupied in breach of the condition.
Yes, under Section 72, it has to be against a licence holder.
Yeah, you enforce against the landlord because the occupier has been in occupation for 11 months during a year. But it's absolutely impossible to establish. It's the same point. You can't enforce against the landlord if he's got a reasonable excuse. If you can't evict them because they're not students, you can't enforce. Well, we don't accept, but it was right for the Court of Appeal to say, breach of condition is enough. If the Act says it's capable of being prosecuted, that gives colour to the nature of the conditions. They have to be fit for prosecution. They have to be capable of being prosecuted. I can't really add to that, the 10-month point. And as I say, I've really set out the reasons why you can't evict in the printed case, and I hope I may be forgiven for not going to them. Finally, my Lord Carnworth brought back this notion of, well, conditions which generally get in the direction of they may not be perfect and so on. This is a completely different sort of law. This law says, and I'm going to repeat myself because it is absolutely fundamental, people are not to occupy below the standards, numbers, standards, criteria specified by Part 2. They are not to do so. The authority cannot waive them, cannot reduce them. Therefore, respectfully, there's no analogy. With planning, there's quite a lot of open textured material, there are much broader considerations and so on and so forth. But in this Act, it has to be actual occupation which meets the standard. Not by most people, but by everyone. They must meet the standard. But I have said repeatedly that that standard may be different if they are really occupying communally and so on, and I do believe I'd now be sort of starting the record over again and doing a full loop if I elaborate on that. Those are our submissions in reply.
Can I just ask you one point? The tribunal judge's decision was February 2016, 2 years ago. Do we know to what extent other authorities have been using this power to impose conditions, or do we have any information about
We have
what
no...
extent other authorities are taking a more flexible view than Nottingham?
I'm not aware of any authority taking the same approach on students. I'm not aware of any authority which is translating guidance like was set out without my learned friend, and imposing them as conditions. It's just circumstances when...
Well, I just wonder whether anyone knows. I'd be interested whether Mr. Moffat, whether the department has any knowledge as to what extent the power apparently given by the upper tribunal's decision has actually been used in practice. I don't know, can I ask?
Well, I think the best I can say to that is that this particular condition imposed in this case is the first occasion to which it's come to the department's attention that the condition restricting occupation to a particular class has been imposed.
That doesn't mean to say it hasn't happened, it's just...
Exactly, yeah. I'm not saying that a comprehensive research project has been done. This is the first time the department has heard about it being done.
Well, we are unaware of it down to the level of upper tribunal, as it were, slightly wearing a slightly academic hat. I've not encountered any case, and we do go down that far now, but I couldn't answer for first-tier tribunal. And
or local authorities, for that matter. Or local authorities.
Or local authorities.
Because, after all, local authorities who are the primary decision makers in this.
Yeah.
Yes.
But
we have. I mean, I was particularly interested by Mr. Fuchs's note, which was produced in the Court of Appeal, and identifies various authorities which do apparently adopt a relatively quite a different approach from yours. You haven't made any inquiries about what they...
No, respectfully, my Lord, this gets back to the fundamental confusion between guidance and conditions. That nobody is operating a substantially different...
We don't know what they do.
Lord, in our experience, nobody is operating a different regime. Everybody is taking the same view that mode of occupation can. And this is just guidance for the public to know when that might be and what the effect might be. It's all it ever has been in 1994, in Dash, and so on. And it's all it can be, because it's the Act which determines it. And authorities always have to consider everything individually. It's all it can be. Lady there, unless there are any more bullets to fire.
It appears not, Mr. Arden.
Phew.
I'm not sure that they're bullets anyway. Well, thank you all very much indeed for your submissions, both orally and in writing. Like I say, we're particularly grateful for the suggestion and the actually having an amicus to help us. Otherwise, we'd only have heard one side of the argument. Well, one and a half. And we need to hear all sides of the argument, and we'll now go away and work out what we think the answer is. Court is now adjourned.